Okay. Looks like we are, right?
I think you are going.
All right. Well, welcome everybody. I know we've already been chatting a little bit, but welcome officially on this, in some places, as Mac would say, some gloomy Thursday time period that we have here. So I first want to start off with the statement. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before the subcommittee with respect to which there is a conflict of interest. And hopefully that really is not the case on this particular subcommittee. But if for some reason it is, please let us know and we will note that. And then we'll move on to introductions. So I'm Dorothy Hairston Mitchell. I was chosen to be the chair of this subcommittee. I am in my second term on the council. Yes, my second term on the council. I had to think about that. Yes, my second term on the council, and I look forward to working with you all on the subcommittee in this regard. I teach over at the law school. I run the juvenile law clinic, as well as teach criminal law and some other pleadings and practice classes here at North Carolina Central University School of Law. So it's good to be here with you all. And then we'll just move. I see.
You might need to call on the next person.
That's what I was going to say, Miss Morris. So I'm going to call on you and then you call the next person.
I am Gina Morris. I practice family law at James McElroy and Deal. I am in my third year of my first term on the council, and I'm really excited about this committee. And I call on Davis.
Good afternoon. I'm Davis Poisson with the law firm Poisson & Bauer. I'm in my first year of my first term, so haven't even completed a full year yet, but I practice primarily personal injury litigation law here in Anson County and kind of all over the state and down in South Carolina as well. And I will pass it over to Ms. Lewis.
Hey everybody, I am Takia Lewis. I practice in Hertford, Bertie, Northampton counties. I do most of criminal work. I have a practice with my dad. I think this is my third year. I don't know, 2020 just throws me off. So I'm glad to be here. And so I will pass it over to Carmen.
Afternoon, everyone. I'm Carmen Bannon. I just had my 15th anniversary of joining the Office of Counsel at the State Bar. So I've been doing this for a minute, and I moonlight as an ethics professor at UNC Law School. And perhaps unfortunately, this is one of my areas of expertise, this topic. So I'm here to try to help us muddle through.
Awesome.
Oh, let's see. Catherine.
Well, I'm the State Bar Counsel, and I don't know anything about this topic. So I'm here to be educated. But I do know that Carmen handles a lot of these sex cases, so you're in good hands with Carmen.
Sorry. Go on.
Oh, Daryl.
Yes. Can you hear me?
Yes.
Yes.
Okay, good. I'm Daryl Davidson. I'm a partner at Bimbo Davidson and Martin and Station. I practice criminal and family law. I'm actually new to the State Bar Council. I didn't really know a lot about this, this committee, but when they said something about sex, I said, I think this might be interesting. So, I'm actually glad to serve and whatnot. So I think it'll be an interesting topic. And let me see who I can pass the mic to. Mr. Willoughby, has he talked yet?
Hopefully not much. No, I'm Colin Willoughby. I practice at McGuire Woods in Raleigh and do government investigations and white collar criminal work. And I've been on the Bar Council for a right good while, and I'm on the way out the door.
All right.
I guess
That's what you think, Colin.
Yeah.
They never let you go.
It's like 7th grade. They just keep you because they like you an extra year.
Oh, Lord. Then we have Mac.
Thank you. I'm Mac McCarley. I practice in the Charlotte office of Parker Poe, mainly doing local government, economic development, and sports law. And I'm in my 9th year with one most
And then Brian?
I'm Brian Oaten. I'm the State Bar's Ethics Counsel and Carmen's paralegal and support staff for this this particular subcommittee.
All right, well, thank you all for those introductions. And I do appreciate, we appreciate, and I'll say that on behalf of myself and Carmen and Brian, for you all agreeing to serve on this subcommittee, because while we're joking and laughing about it, it is a topic that we do need to explore so that we can assist Carmen in those cases that she does receive. And so I think that this was a much needed subcommittee that we do need to have. And so with that being said, we'll move on through the agenda as it is printed. You all should have received that agenda. And so we'll hear from Carmen on the overview of disciplinary action under this particular rule, Rule 1.19.
Thank you, Dorothy. And what I'm going to do is I'm going to share my screen because I recently gave a presentation to a national conference of Bar Council about this, just explaining to them how these cases are handled in North Carolina. And I figured it would be helpful just as by way of orientation for this group to get that same overview. So let's see if I can get this to work the way I want it to. Brian, is it working the way I want it to? Okay. So just starting out here with the basics, I just have the text of our current Rule 1.19 here in the text box. And by way of comparison, I've also put down at the bottom of the screen the ABA model rule on this topic, which, as is often the case, is much shorter than the North Carolina iteration. We tend to have more definitions and explanations in our rules than the model rules. And that is also the case for this particular prohibition. So when you look at the survey of states that was provided in the materials, what you see is that North Carolina on that spectrum is one of the more robust, I think, and well-defined and broad versions of this rule. So there's, so far so good. But there are some things that we might want to revisit just given the modern age and the trends that we see in terms of behavior. So this is where we start. And then I'll talk a little bit about the cases that we see that we prosecute under this rule. Let's see here. So this is one of my most famous might not be the right word, but this is a notorious case, I suppose. It was made it to national bar publications and the like. This was a lawyer in North Carolina who came to the state bar's attention because he had been using a law firm issued cell phone to send pictures of his genitals to multiple domestic clients. One of them eventually got a new lawyer, mentioned this type of communication that she had received in the past from her lawyer, and that information made its way back to the firm, where the cell phone was immediately confiscated and sent to us. And we got to examine the entire contents of that photo library, which is not for the faint of heart. So in this case, I show you first part of the complaint in this case, and this is mostly to illustrate kind of how I'm inclined to plead them. I think some other deputy counsel are more less detailed in their pleadings, but my feeling is that once we have proof, usually indisputable proof that this conduct has taken place, it's really not our job to try to soft pedal that. So I tend to tell in the complaint exactly what we actually know. And in this case, we had a wealth of text messages. So there were some choice quotes in the complaint. Now, this particular lawyer, Mr. Rahili, was suspended for 5 years. He had this kind of communication with multiple young, vulnerable domestic clients. And then he also, in addition to sending the material, also had sex with more than one of them. So he definitely fell into the serial exploiter category, and he ended up being suspended for 5 years. He is only permitted to return to the practice of law if he's able to find 2 clinicians who are willing to certify under oath that he is of no, I think it's something like of no greater risk of boundary violations than the average lawyer, or something like that. So he has a very high burden to show before he would be allowed to be readmitted. Go on to another case. This one is more an illustration of how sometimes the initial boundary violation, the creation of the sexual relationship with the client, is really just the beginning of what then snowballs into a rather astounding sequence of ethical breaches. This is a little timeline from this case where you see the lawyer's representation of the client is the first thing. Then during that representation, he started having a sexual relationship with her. Almost at the same time, he decided to run for the district attorney position in his county. While that campaign was still ongoing, the client's husband learned that they had this relationship. And in order to do damage control, the lawyer first threatened his client that he would see to it that she lost her children if she didn't lie about the fact that they were having sex. He actually went so far as to prepare a false affidavit for her to execute to that effect. She later decides that she's not willing to do that and comes clean and admits that they've been having this relationship, which prompts her husband to file an alienation of affection suit against the lawyer. Keep in mind, the campaign for district attorney is ongoing when this becomes public and becomes a public filing. He immediately turns around and, in order to try to silence the client, sues her for defamation in what is of course, a wholly frivolous lawsuit, because he knows that what she has said about him is in fact true. Not satisfied with all of that type of blackmail, extortion, etc., he also threatened his paralegal threatened her should she be considering revealing what she knew about the sexual relationship. In addition, he did things like make false statements to the state bar, make false statements to law enforcement. Eventually, he was criminally convicted of, I believe, threatening a witness and I'm sorry, what's the one about the administration of justice? I'll get there.
Conduct prejudicial to the administration of justice?
No, I'm talking about the criminal offense. Obstruction.
Oh, obstruction.
Yeah, obstruction of justice.
It just, sometimes you just have to talk your way to the answer. This was really truly a disastrous set of facts. Some of the most spectacularly bad that we've seen, but it is not unusual that while the boundary violation is bad, what follows makes it considerably worse. A few slightly different twists on this theme. The first one actually doesn't involve Rule 1.19 at all, but I just thought it was entertaining. We did have a lawyer surrender his license because he had been caught with a toilet cam in his law firm, and I think he knew that was just not something that it would be worth his while to litigate in this forum. And then another interesting twist, which was from a prosecution under this rule, was that the client and lawyer had actually had a legitimate relationship that ended in marriage, even though it had started as a violation of this rule. So that lawyer had a much more mitigated outcome than he would if the marriage had not taken place. And please, if you have any questions, as I'm going through, please let me know.
I have a question. In that
Yes.
particular case, was there any indication that they actually got married in order to mitigate, or did it seem to be a legitimate, like?
No, it was. It wasn't, that one actually wasn't my case, but my recollection is that we didn't even find out about it until sometime later. I don't know if Mac or Brian remember or if Catherine remember the facts exactly, but I don't think it was a cover effort. That would be a very nice thing for that client to do, but if that were the case. This is one that was just fascinating to me. This lawyer who, I'm sorry, they're all fascinating, but this is not the one I was thinking of. This is an instance where the lawyer was carrying on relationships with two different clients. He ended up either employing them, giving them money, giving them loans, giving them gifts. There was a lot of, they were receiving a lot of financial benefit from the relationship with him. And that's something that was, of course, asked about when we were interviewing him, investigating this matter. And he claimed to us that this was just because they were, they were in these relationships. They were just the regular generous acts of a man who had a girlfriend. But unfortunately, he had previously engaged in correspondence with them where he specifically referred to what he had paid them as hush money. So that didn't end up working for him, that defense. Now, in these cases, just for context again, there are often other rule violations that are closely associated. The one that is perhaps most important for what this subcommittee is going to look at is the fact that we do often end up pleading a Rule 8.4a violation, which is applicable for any attempt to violate another rule. And we will plead the kinds of transmission or requesting of explicit materials, and not as a freestanding rule violation, but as an attempt to violate the sex with client rule. And that, of course, requires us to potentially argue about what the lawyer had in mind at the time those materials were sent. And that, of course, is always difficult to prove what was in someone's mind. So that can be one challenge with these kinds of cases. Generally, we have been successful, but it takes more time and discussion to get there than it would if the conduct was in itself prohibited. Another rule violation that we often pair with a 1.19 violation is just a regular conflict of interest, the kind of conflict of interest that arises when a lawyer's personal interest may materially limit the ability to represent that client. In the most recent case that I tried on this, we were able to prove the Rule 1.19, but the DHC did not find that the sexual relationship actually had a material likelihood of prejudicing the representation. So just because there is a sexual relationship doesn't necessarily mean that we'll be able to prove there was a more generalized conflict. In other words, we won't necessarily be able to prove that the representation was likely to be affected. It really depends on the nature of the representation. So that is another thing we have to wrestle with sometimes in these cases. And then finally, we often do see a lot of things like business transactions or just financial assistance, simply because the attorney-client relationship is no longer has those defining boundaries that it's supposed to have, and therefore we see some of these other types of violations creeping in. Some of the common themes and factors, in these cases include vulnerability of the victim. As you can see here, I've just put up some language from some of the existing disciplinary orders on this topic. We see here a victim who had mental health challenges, emotional vulnerability. We almost always, I actually think every one of these cases that I prosecuted has been in the domestic sphere. So the idea that it is domestic lawyers and clients seems to be very common. And in fact, I noticed that in New York, their rule is specifically limited to domestic cases. Their broad prohibition on sex with client is only in domestic cases, which perhaps suggests that they had already recognized that trend when they made the rule. So we see this, I have yet to have an instance of a Rule 1.19 violation that was perpetrated by a female lawyer. I'm not suggesting that does not happen. I'm not aware of it being brought to our attention. So yes, usually domestic clients and they who are particularly vulnerable in some way. And that is what is motivating to me about these cases, is that they generally, they often will involve some aspect of preying upon the vulnerable. And it really throws into relief how antithetical this is to a fiduciary relationship when you see these young women usually testifying in the courtroom across from a much more sophisticated lawyer who decided to parlay their representation into this relationship. I do want to, just for historical reference, show how times have changed in the way that the hearing commission, and I suppose maybe even the grievance committee, thinks about this kind of violation. So what I'm showing you here is an outcome from 1993. And this was before we had a specific rule against sex with clients, but the conduct is obviously of the sort that would fall under that rule now. This is a lawyer who on more than one occasion demanded that he be allowed to give a spanking to a teenage girl who was his client. In 1993, he was given a censure, and I believe the theory was that this was actually a criminal offense. But if were this to happen today, I am quite certain it would not be resolved with written discipline. These days, generally for a single instance of, a violation of this rule, we will see a 1-year active suspension. If there is more than one instance, the suspension will usually be longer. For real serial predators, they have been disbarred, and also the lawyers who pile on with additional rule violations are generally disbarred. So we do not see these cases being resolved with written discipline in the modern era. Yeah. Okay, so I realize right now that I forgot to change my animation. So I'm going to go to the next slide, and I'm just going to apologize in advance for what you're going to see when we get there. So talk about digital evidence here, about the kind of evidence that that I have the honor of sifting through when we get these kind of reports. And because of the way people communicate with each other these days, we end up getting a lot of pictures and a lot of text messages. And occasionally we have needed to use a forensic analyst in order to extract that information. But more often than not, it's not disguised, it's not been deleted, it's just out there in the world, including photographs. So this is the kind of thing we see. These text messages actually are from between a lawyer and client. And you can see they are discussing, he is discussing with his client the existence of the bar rule prohibiting them from having sex. He is under the misapprehension that there's some sort of waiting period afterwards, but he does seem to understand pretty specifically why this is a problem. And he's explaining that to her in the same conversation that he is sending her a photograph like the one on the left side of your screen. So this is what we deal with very often in these cases. And this conduct in itself is not a rule violation unless we can persuade someone that it is an attempt to have sex with the client. So finally, then that brings us to one of the things this subcommittee is going to look at, which is whether it would be worthwhile and appropriate to expand the scope of what this rule prohibits to include the transmission or requesting of explicit images. And David Allen suggested another way we could structure this. So when we get into talking about this, I'll show you maybe 2 different ways we could have this added to the rule. So that is my little introduction to the topic. And does anyone have any questions about that? All right. So Dorothy, what shall we discuss?
If you're ready, if you want to go into that proposed addition
Okay.
that you have there.
Yep. I will do that.
Or maybe the amendment, I think actually, and I'm sorry, Carmen, I should have said this before, the additional, the other state approaches. Do you think it's?
Yeah, and I was not going to go through those in any detail at all.
Okay.
Because we wanted to look at the rule globally and see if there were any ways we could improve it. I thought it would be worthwhile to see what other states have done. For the most part, other states' rules seem to be less inclusive than ours. Some of them have additional language about whether there's a marriage relationship between the lawyer and client, which I think if I'm understanding it right, it contemplates that the lawyer is representing someone, gets married to that person, and then has sex, then that's okay. I believe that is the situation that's designed to capture. I'm not sure that that's necessary, but that is one thing that is mentioned. Other states also include provisions about how this applies, or if it applies for an organizational client. I think, that's interesting. I've never seen this come up in that context. So I don't really have an opinion about whether that is necessary or useful. So I don't know, Brian, you read through those too. Were there any other twists from other jurisdictions that you thought that you just noticed?
No, the one that you just referenced about the entity, I thought was probably the most interesting one. That was out of Minnesota. But I don't recall from my time in the Office of Counsel that situation coming up. And frankly, I guess that situation, I feel like there's probably other rule violations going on if that's if that actually did take place. But the thing that I guess I was just looking up, because I remember as I was scrolling through here, I saw, Virginia does not have a rule. And I remembered reading something, and it was really just last month that Virginia, or I guess, I don't know if I can't recall their exact structure. I believe they have a state bar and a council type body, but they actually rejected a rule 1.19, or I guess it was a proposed amendment to rule 1.8, to say that it was a conflict to engage in sexual relations with your client, and that was rejected just last month. So it's kind of fascinating to me that this is still, I guess, a debate.
That's right. That's right. And Texas has also declined to adopt it in fairly recent history. And I forgot to mention that when I was talking about our rule, which is that it was adopted in 1997, and according to lore, it was adopted by an evenly divided council, in which Judge Erwin Spainhour had to cast the tie-breaking vote as president of the state. So even in the late 90s, this was not universally accepted as a good choice. And in other jurisdictions where it has yet to be passed, they are enforcing they are going after this conduct exclusively by having to prove that it was likely to materially prejudice the representation, which is, as I learned in my recent trial, a higher burden to prove, for sure.
And
so,
Carmen,
one other. I'm sorry, go ahead.
No, go ahead, Dorothy.
One other nuance that I saw looking at the different state by state analysis was some of the states including that provision about not only not having sex with your client, but with a representative of the client that exploits or adversely affects their the interest of the client. So I thought that was interesting in some of those states too. And I wondered if that was something that we might want to explore, especially in the area that I thought of immediately was when you have juvenile clients or child clients, and then the parent or someone having a relationship or being exploited, or that relationship being exploited because of the, you know what I mean, the parent having a sexual relationship with the lawyer.
That's really interesting. I confess when I saw that, I thought, I just assumed they were talking about organizational clients, but you're right.
Yeah.
It doesn't, that's not what it says.
Mm-hmm.
Interesting. Okay.
I see Mac has his hand up.
On the issue of the organizational client rule, I really don't think that's necessary, given that I think Title VII probably covers all of the things that you would expect to be covered in an organization that have to do with sexual harassment. It seemed to me to be an unnecessary rule in an organizational concept.
So Mac, would that apply if you were not in-house counsel though? If the lawyer just had an entity client?
How do you figure? Well, maybe. I see your point. If I think it gets a lot more complicated trying to figure out in that case who has the superior position, who is being victimized.
I understand that. Yes, I think that was part of my hesitation about it too. Just the sophistication of the entity client and the leader, you know, the people who run an organization is a whole different thing than what we actually see happening on the ground. So
I also don't sense that there's a tidal wave of those cases coming into your office.
no, not or none.
Yeah.
Mm-hmm.
And Carmen, just as some context, I guess, for those on this subcommittee that were not on the other subcommittee that really kind of brought this idea about. This originally, I thought it'd just be good to kind of flush out that the ethics subcommittee studying whether or not the rules of professional conduct should contain anti-discrimination language. Went through a number of hypotheticals, some of which were based, excuse me, on actual cases from other jurisdictions. And some of those fact patterns really kind of brought about this question. Because
right. I mean, you're gonna tell them which one, the one.
Yeah, well, I thought the best example I thought was best, and you know, once again, another example of just worst conduct. Really was I believe this is a case out of Colorado where a lawyer essentially tried to offer a discount to clients in exchange for the client sending nude photographs to the lawyer, like 5% off or something like that, their legal bill. And so when we were looking at those scenarios and looking at our current rules in the context of, you know, whether there should be anti-discrimination language or sexual harassment language within the rules of professional conduct, you know, those types of cases kind of brought about this question of, you know, even I guess comparing what we've seen here in North Carolina, like Carmen's has gone through in the different cases that she's tried. We've tied it to 8.4a as an attempt, but in that particular scenario, I think the entire subcommittee looked at that and said that conduct should be dealt with by professional discipline, but we really don't have a rule. And it's darn near impossible, I think, to actually tie that or call it an attempt under 8.4a. It wasn't an attempt to.
I would say no. I mean, that was my point to the subcommittee is I couldn't prosecute this. We do not have a rule to cover this. We should, but I mean, the lawyer would say, no, this has nothing to do with, you know, actual sexual contact. I just like naked pictures and I'm willing to give discounts for them. I mean, that, and there wasn't much I could do about that, I think, unless we changed our rules. So yeah, that is how we got here. That's really helpful, Brian. Thank you.
All right. So I think we're good to go to the proposed addition, if that's okay with you.
Yep.
Unless anybody else has any questions or comments on the other state approaches.
Okay. So this is, get this to here. Sorry about this. This is what I sent you. What I sent you initially was this proposal that would leave the structure of the rule intact, you know, relying on the prohibition against having sexual relations with a current client, but then expand the definition of sexual relations to include this paragraph about the transmission of sexually explicit material. And so that was the first option. As I said, David made a suggestion that perhaps this doesn't need to go here, that the prohibition that we are considering could just be a freestanding paragraph, which I personally think is a good idea. I think it flows better. It doesn't contort the definition of sexual relations. So another option, I'll just scroll down here, is this, which is we leave paragraph D alone and then could add a separate paragraph that gets to the point. And you'll notice if we were to look at it that way, it would need to be phrased differently. The best I could come up with on the fly was something like in communications with a current and then I realized probably a prospective client would be a good idea too, because the rules do define prospective client. It is a term of art. It doesn't just mean anyone out there in the world who might become a client. It is someone who actually confers with the lawyer about the possibility of forming an attorney-client relationship. And so that has, I think, sufficient specificity, because you could see that this behavior could actually begin during or at a consultation, or after a consultation, but before there was a formal attorney-client relationship. And that's really no better. So that's the second option.
Carmen, I have a question about the language. Are you confident that the phrase "or other content" is specific enough to pick up these sexually explicit texting messages?
I am not confident in much of anything, really, Mac. That's a really good point. I suppose it could actually start with messages, right? We could include that specifically.
It seems to me that one of the common things that we would want to tell lawyers they should not do is sexually explicit texting with clients or prospective clients. And I would hate for somebody to wiggle out of that particular charge by saying, or other content isn't specific enough.
Right. So do you think that would be enough?
I do.
Okay.
Mm-hmm.
And I'm not sure what other content would be, but as a lawyer, I believe we're always inclined to include a catch-all phrase just in case we miss something. So that's why that's there. Any other thoughts?
I just have another question. What would be the benefit or detriment to approaching this either way? With the having it as a number
versions?
3, right? Having it as a number 3, or is there any? I mean, I know we've, especially for the new folks, I know I've been on here long enough to see if we've done amendments, you know, requested amendments in different ways, but I'm not sure if there's a rhyme or reason behind the approach necessarily. Because it seems like these both get us to the same point, right? But
well, I guess technically the first version that modifies the definition of sexual relations, that would not include prospective clients. which I'm not wedded to. Again, I just thought of that as I was drafting this up. But so that's one difference. Otherwise, I think it does get us to the same place. I think it's just a question of, do we think it makes sense or reads better to call this a type of sexual relations, or just to designate it as a related but different form of inappropriate conduct? One thing I did highlight down here was if the subcommittee is inclined to recommend a separate paragraph, does that mean that the title of the rule is no longer entirely accurate, in that the rule as currently is titled sexual relations, and this would be sexual relations and other stuff? So that's another thing to consider.
Hey, Carmen, what about, I like the option of adding a paragraph E as opposed to broadening the definition of sexual relations to go beyond actual physical contact. But what about the title being relations or communications?
Oh, yeah. I mean,
So would that be, do you mean relations or sexual communication?
Yes.
To be more specific, yeah.
would it, I guess it would be and, right?
And then I was wondering too, like with that question I had about, or the nuance that I was speaking about with the state by state rules, because I didn't see that we had the titles of the rules from the other states to be able to see.
We don't, and I think in part that's because a lot of states have either adopted the model rule outright or adopted their language in the same place that the model rules include this prohibition, which is in Rule 1.8, which is the list of specific ways that we can have conflicts with our current clients. So that's why they don't have separate rule titles. They're just one of the many specific types of current client conflicts.
Gotcha. And I asked that kind of looking forward to if we are going to look at that whole sexual relations with the representative of the client. Because if it's still just listed as sexual relations with clients prohibited, then that's just looking down the road for that.
I have a question.
Mm-hmm.
Let me see. Can you hear me?
Yes, sir. We can hear you.
Oh, okay. I'm sorry. You're going to have to define sexual communications too if you're going to add it to the phrase. I think you'd have to have a definition for what sexual communications are.
Well, do you think that if this paragraph were part of the rule, so up here, I mean, this isn't enforceable, right? This is just the title, but Daryl, do you think that this is a sufficient definition? Or do you think that, like, are you saying that you think sexually explicit needs to be defined?
No, if you're going to say, sexual communications, then I think that needs to be defined as far as what sexual communications are between, the attorney. I mean, we know what it is, but, what if an attorney says, well, that wasn't a sexual communication. I was just repeating something or this, and it turned into, we had to talk about that. But I just think that you'd have to define sexual communication just like you do sexual relations, right?
So toward that end, I also agree, because I believe the way, and I can't see E right now on my screen, but I believe the way that it's drafted is if a I always go back to bro culture. So if a heterosexual,
surprises me, Gina. It doesn't seem like where you would live.
If a heterosexual male lawyer sends a heterosexual male client a picture of a naked woman, has the lawyer violated this rule? I cannot imagine that we intend for him to violate the rule. But might he? I mean, I know you wouldn't prosecute him, Carmen. I don't know whether you would or not. I wouldn't think that you would. But I guess the problem is that we're trying to avoid a sexual connection between a client or prospective client and a lawyer, and we don't want to go broader than that. I don't think, and I worry that our language is broader than that.
That's a really good point.
That is.
And yeah, I mean, I think that's, we have, it seems like a very hard thing to qualify around. Because again, it's not necessarily that that the only purpose is to prevent the development of a sexual relationship. It's also that overlaying this kind of innuendo, advances, whatever, onto the attorney-client relationship is inherently damaging to it. I mean, whether it's received well or not well, it's inconsistent with the fiduciary relationship. But I see your point that yes, if it was just received as something funny by someone who didn't feel harassed or threatened by it, then that's probably not something we need to get involved with. So.
I think it would be worthwhile, following up on Daryl's comment, to take a shot at drafting a definition.
Right.
Okay.
Just to see where that goes.
Oh boy,
And,
Brian, the two of us are going to have some fun doing that.
That's exactly what I was thinking too, Matt.
And I'm sitting here thinking, this is why I asked off of the ethics committee in the first place, because there are too many angels dancing on the heads of pins. But I think Daryl's right. This might be one that needs some definition.
Okay. Well, that can be a task.
I see Catherine Jean has a.
Yes.
But I can't see it anymore. It's kind of gotten askewed on my screen.
Mine too.
I know. I'm just trying to figure out.
There we go.
How to make.
So I mean, couldn't you just define sexual communications? Or again, I can't see the top, so I don't know what the word. Yeah, sexual communications to be sexually explicit messages, images, audio, video, or other content, and then say sexual communications with a client are prohibited unless the content is relevant to the client's legal matter. So essentially what you have here as the list, and you might want to expand the list, but basically that would be the definition of the term.
Okay.
But the reason I actually raised my hand was because you were talking about, I think in some other jurisdiction, that there was a lawyer who was offering discounts on legal fees in exchange for, I don't know, sex or pictures or whatever it was. And I'm just wondering, I mean, was this directed to people who he was already, who qualify as prospective clients under our rules? Or was it more broadly disseminated, like somebody would run some sort of ad thing on the internet saying, come be my client and I'll give you a discount. I don't know. If there is a concern about lawyers saying horribly undignified things like that on the internet to people who are not current or prospective clients, then you probably need to think about whether you want to try to address that here, or whether that goes under the advertising rule, or whether it doesn't need to be addressed. Do you know what was correct?
So yeah, the case itself that I referenced before was an actual client.
Okay.
And it was one of those situations. That's what I was trying to think about here is the person. I don't think the person was a former client just yet. There was still a bill to be paid, but I believe the representation, the legal work had completed. And I don't know if that creates some sort of, little kind of aspect here to take into consideration. But I would not consider, I think when there's still, the legal work is completed, but the lawyer and the client are still kind of wrapping up their business, the transaction, I would still consider that person a client. So I don't think you need.
We could also theoretically plead that was some sort of solicitation. Yeah. I mean, that he's offering basically money for sex, although not for pictures. It wouldn't count. for if it was just pictures. So again, we're back to that distinction. I mean, there will always be some creative fact pattern that we can't capture.
Right.
But I do think it's worth trying to decide if it's worth having a rule that captures facts that we know occur, like that recur. So that's, yeah.
Yeah, and I'm thinking the the notion of trying to kind of craft something that would address any sort of just truly undignified conduct that's a tough one, I think, to actually draft the rule that would not be too broad. But I think the purpose of the rule here is the exploitive nature of this type of conduct. And so when you have an established client relationship and you're asking for whether it's physical interaction or pictures, you are, as the lawyer, in a position of authority over that person, and that's really what we're, I think, getting at here. So yeah, I think I think all the comments here have been really helpful to try to see how we can actually draft this rule to get at what we're trying to address.
Just a question. I'm not sure. I think it's a suggestion yet, but just a question. Police departments, fire departments, the military have a generally called conduct unbecoming rule.
Mm-hmm.
Is there a way that we can somehow, in the subjective world of the crazy creative ways people can be offensive with sexually explicit issues, can we have a conduct unbecoming provision?
That scares me a little. That phrase, in terms of vagueness and overbreadth. I mean, I did see in the other states' materials that one of them has a rule that prohibits conduct that shows bad morals, which, I mean, my jaw dropped when I saw that. I mean, who even knows what that means anymore? But also, how do you enforce that? So I understand what you're saying. I think it would be an uphill battle to craft something that held up.
All right, let's go a different direction. I like what Brian was asking a minute ago, which is the issue of what's the harm we're trying to prohibit, and it really is that victimization of a client or prospective client by a lawyer. Can we go at a reasonable person's view of this conduct, that it, without an intent or motive element to the rule, but that to a reasonable person this would appear to be exploitive?
Yes, I think, yes, sure, we can do that. And that's a good way to think about it, because a lot of times at the time, and sometimes indefinitely, the client doesn't necessarily identify it as exploitive, doesn't necessarily recognize it as such. So we would want some kind of objective standard. So,
and that would probably handle Gina's case of two male lawyers trading pictures.
So
There's
Gina,
no
I did
exploitive
find
motive.
a way to try to capture your comment, Gina. I hope this works. How can this be limited to exclude communications in the Broniverse?
We'll put that in the comment.
Okay.
I see, Carmen, we have like 5 minutes before the top of the hour, and I know that we try to keep these subcommittee meetings to an hour. I think it's been some really good discussions here. You think it'd be a good place to stop here, and you all work on those definitions? And
absolutely, this is great. This is really, really helpful. Gives us something to work on, and yes, we will go back to the drawing board and see what we can do to improve this, and reconvene, I guess, probably after the quarterly meeting.
It looked like Mr. Davidson, did you have something? You
Yeah,
got
I-
up
I-
close to the screen, and that's the
Yeah, I
universal
was
sign
wondering,
now on
you know,
Zoom that you want to say something.
a prospective client. How long is a person a prospective client? Heck, the person in the ambulance going to the hospital could be my prospective client for a personal injury. You know, I'm just saying.
Right. And so that's actually, that's what I was trying to hit on earlier, which is that term is defined in the rules. So it is not, we don't have to rely on a sort of, I mean, it's someone who has actually has actually conferred with the lawyer about forming an attorney-client relationship. However, even then, even to your point, the question is, when does that person stop being a prospective client and go back to being nothing? Right.
When they don't pay the fee.
Right. Well, no, not that. That's never a good defense. But yeah, no, that's a great point too. I'm gonna put another note on here for revisions about looking carefully at prospective client and how long a person would stay in that category. So thank you.
Carmen, if this meeting lasts much longer, you'll have more assignments. You need to call a halt quickly.
Yeah, Dorothy, get us off the hook.
I'm trying to help her out.
Well, just really quick, just a matter of kind of housekeeping. Speaking of assignments, I presume, Dorothy, that you'd like Mr. McCarley to attend the ethics meeting and stay the whole time and provide a report.
Absolutely.
The subcommittees were no, sorry, Mac. Sorry.
Full report with PowerPoint.
With PowerPoint.
Oh gosh. But this was a good discussion, you all. I appreciate everybody's time, and we will get from Carmen and Brian about the next meeting, which will be after our quarterly meeting. And I'm sure that if you have some things that you need to touch bases with us on in between now and then, you'll let us know via email. And if something just pops up and you're like, I just need to get it to them so that we can have it for next time, please send it to them, but send it to me and them via email, and we'll have that included in those next materials. I think this was a good discussion.
Absolutely, and thank you all for your input. It's great and helpful.
Carmen, that material you sent was excellent. Reading through all of the different rules, I mean, that prompted a lot of questions for me and kind of helped put context on it. That was really helpful.
Great, I'm glad to hear it. All right, everyone, I look forward to seeing you soon, in a few weeks.
All right, y'all have a good one. Thank you again.